Welcome, everyone, and thank you for joining us. We're excited to present today's session, Navigating Wound Care, Strategies for Compliance and Defense. I'm Brandon Zarsky, a partner in the healthcare group at Frier Levitt. I work with physicians, medical practices, management services organizations, and healthcare facilities on a broad range of regulatory and transactional matters. My practice focuses on helping clients navigate corporate transactions, compliance with laws like the Anti-Kickback Statute, Stark Law, corporate practice of medicine rules, and fee-splitting prohibitions. I also play a leading role in our firm's wellness and anti-aging practice group, advising med spas, IV therapy clinics, and aesthetic practices on regulatory strategy and corporate structuring. In addition, I handle healthcare M&A transactions, representing clients on both the buy and sell side, and supporting post-deal integration, which we'll talk about a little bit in the wound care space today. Most relevant to today's presentation, a significant part of my work also includes advising wound care providers, management services organizations, vendors, and other industry stakeholders on building compliant referral relationships and managing reimbursement and licensing challenges in today's evolving healthcare landscape. I'm pleased to be joined today by my colleagues Guillermo Beades and Arielle Miliambro as we explore the growing regulatory challenges in wound care and how providers can stay ahead of them. Today's presentation will cover how key laws like the Stark Law, Anti-Kickback Statute, and False Claims Act impact providers. We'll also highlight common compliance risks, including referral issues and documentation gaps, tips for navigating wound care transactions, and we'll share some practical strategies for building effective and internal compliance programs to help protect your practice. Guillermo, could you please introduce yourself?
Hi, good morning, everyone. My name is Guillermo Beades. I co-chair the Insurance Defense Group here at Frier Levitt. Most of my work lately has been defending audits and overpayment demands, particularly from the CMS, which has been very active in this space. And they have a significant amount of interest in the last 18 months in wound care because it's a very high paying procedure. In addition to that, my group also handles a considerable amount of Board of Medical Examiner work and state investigations, mostly on the regulatory side. From time to time, we are also representing doctors in civil federal cases that involve allegations of inappropriate billing and documentation, where we have the bulk of our experience. We've helped practices save millions, and we've been defending a lot of audits in the high seven-figure range lately, particularly since the Medicare wound care audits are very high exposure. Thank you, Brandon.
Thank you, Guillermo. Arielle, could you please introduce yourself?
I'm Arielle Miliambro. I'm a partner in our regulatory group, and I focus on matters related to fraud, waste, and abuse, privacy and security, professional board rules like those related to fee splitting, scope of practice, prescribing and dispensing requirements. And I also do a lot of work with telehealth and digital technology as well.
Thanks, Arielle. Before we get started, just a few quick housekeeping items. This webinar is being recorded, and you'll receive a link to access the on-demand replay in the next few days. Please note that while we are attorneys, today's discussions for informational purposes only and should not be considered legal advice. We'll be addressing these topics at a general high level. If you're interested in a more in-depth conversation, we'd be happy to connect. Our contact information will be provided at the end of the presentation. If you have questions during the presentation, please use the Q&A tab. Be sure your name is visible so we can follow up if we're unable to address your question live. We'll answer as many questions as time allows at the end, and for any that we don't get to, we'll follow up with you directly. If questions come up afterward, we also encourage you to reach out to us at any time. I'm now going to hand the mic off to my colleague Arielle, who will kick us off with a discussion about practice structuring, mobile wound care considerations, and a discussion on fraud, waste, and abuse concerns in the wound care space. Arielle?
Thanks, Brendan. So as a threshold matter, there's two basic practice structures for most wound care businesses. The first is a direct practice ownership, and the second is what's commonly called an MSO or management service organization model. When establishing a wound care practice, the first decision is often which of these models to pursue. One issue that may impact the decision is related to the corporate practice of medicine or the prohibition of the corporate practice of medicine. In over half of states, corporate practice laws restrict non-physicians from owning or controlling medical practices. This means that only licensed healthcare professionals, typically physicians, sometimes other clinicians, can directly own and operate a wound care practice. And the core purpose of corporate practice is to ensure that only licensed healthcare professionals are making medical decisions and protecting patient care from commercial interest. It's also intended to preserve that independent clinical judgment of providers. In strict corporate practice states, New Jersey is an example, California is an example, typically only a licensed physician, or in some cases, like I mentioned, other licensed healthcare professionals can own and control a medical practice. So non-clinicians cannot be shareholders, partners, or even directors sometimes of the professional entity that's delivering wound care services. And because wound care practices are really just medical practices, unless they're organized as a licensed facility, corporate practice rules may also require them to take a certain designation when forming, such as a PC or professional corporation or PLLC. And these designations further restrict ownership. In states with less restrictive corporate practice rules, non-physicians can frequently hold a minority interest, but the majority control has to remain with a licensed professional. And then there's also states without any corporate practice rules, and a non-clinician can be an owner, and they can be the exclusive owner. But sometimes these states will require the practice entity to register as a clinic. Florida is an example of that. So it's important just to understand what each state's corporate practice rules are. To navigate corporate practice limitations related to ownership, many wound care businesses are using a friendly PC or MSO model, where a physician-owned professional entity contracts with an MSO for non-clinical services. That could include billing, HR, IT, supply chain management, and so on. This structure can allow for that capital investment and participation in the overall business without violating corporate practice rules. It can also facilitate multi-state expansion and operational efficiencies. Importantly, though, the professional entity has to retain full authority over all the clinical matters, including the ultimate hiring and supervising of clinical staff, establishing treatment protocols, and making patient care decisions. For mobile or multi-state wound care practices, corporate practice compliance can be evaluated or must be evaluated in every state where services are being provided. The law in the patient's location is what's going to govern, not the state of incorporation or the headquarters of the practice. So this means that a mobile wound care practice operating in multiple states may need to establish separate professional entities in each state, depending on what those jurisdictions are. And even where separate entities aren't required, stakeholders need to be aware of how their entity can operate or not, based on the law, again, where the care is being delivered. In addition to making sure the entity itself is permissibly structured, there's also the question of whether or not the entity must foreign qualify in another jurisdiction in order to render care there. Foreign qualification is essentially the process by which an entity itself registers with the Secretary of State in another jurisdiction to provide notice that it's going to be doing business in that state, which would be the case if the practices are dispatching providers across state lines. Depending on corporate practice rules, certain states, like I mentioned, the stricter ones like New Jersey and California, don't allow for foreign qualification of a medical practice. So anyone who's in this space just really needs to be aware of that. And just as a result of these corporate practice issues on the whole, many models that outwardly appear to be national are in fact multiple practices operating sort of as a network, and they're frequently branded by an MSO that acts as this centralized hub or administrative service entity relevant to the model. Violating corporate practice can result in severe consequences, particularly for the licensees, including license suspension or revocation. It can cause invalidation of contracts. There are civil penalties, and there could even be theoretical criminal charges for unlicensed practice of medicine, if that's deemed to have occurred out of the MSO or by the MSO. State medical boards regularly enforce corporate practice issues, and providers participating in non-compliant structures, even if they don't know, can face disciplinary action. So for wound care practices, strict adherence to corporate practice is essential. All the clinical operations have to be under the control of licensed professionals, and the business arrangements have to be carefully structured to avoid even the appearance of non-clinician influence over patient care. Where a non-physician has an interest in developing the business model, or even if a clinician is the lead in the business model, but they simply don't want to be the owner of the practice, they don't want to be involved in the clinical side, which is something I'm actually seeing quite frequently. These individuals need to be aware of how to appropriately structure the MSO and how to implement that. In terms of the MSO's function, it can provide, like I said, billing, HR, IT, supply chain management. It can do marketing, among a number of other services, as long as the professional entity is, again, retaining control over those clinical decisions. The MSO is then compensated by the practice through management fees. These fees have to be set at fair market value for bona fide services in order to avoid regulatory scrutiny. Excessive or percentage-based fees that are tied to clinical revenue can raise compliance issues, which I'll get into in just a moment. What we commonly see in MSO models is a cost-plus management fee, where the manager takes all their costs associated with rendering their service and then marks those expenses up by a set fair market value percentage. In addition to the management fee, particularly in the wound care space, we've also started to see some organizations looking to find other revenue drivers aside from the management fee. So, for example, we're seeing management companies explore whether they can also form a GPO in order to participate in the skin substitute purchase volume. We're seeing folks explore whether they can independently create a registered wholesale distributor and then be the seller of those skin substitutes and other applicable products to the wound care practices so that they can capture that margin on products that otherwise might not be available if their role is exclusively as a manager. Adding to the management model is possible, but ultimately the totality of the relationship has to be explored and evaluated, particularly from a kickback perspective. Just to focus on mobile wound care companies in particular for a moment, there's some considerations that are unique to these models and then other risks that apply just across any wound care business. In terms of what is unique here, practices need to be cognizant of where they're rendering care and whether the medical practice entity is duly registered and properly formed to actually serve as a medical practice in the state where the provider is traveling to. They also need to be sure that the staff they're engaging are properly licensed to treat patients in the states where they're being dispatched. Because of the likelihood of crossing state lines, there's other considerations as well in terms of scope of practice and supervision associated with any mid-level provider that's rendering care. Brandon's going to get a little bit deeper into that in a moment. But just as an example, if one state has autonomous practice and a nurse practitioner is hired to render care in that state and a border state, and the border state requires physician collaboration, that just needs to be addressed and accounted for by the practice and physician collaborator. Mobile wound care providers also have to consider the logistics of traveling with products such as skin substitutes, managing temperature control requirements, ensuring that products aren't compromised while in transit. There's also the concern of maintaining proper inventory counts when products are being moved from site to site. And if any ancillary products or drugs are required, then there are separate Board of Pharmacy concerns that may govern the transport of those from place to place. Mobile wound care practices also have to ensure that they have reliable and secure EMRs that can be accessed by their providers in real time to enable care. This can become challenging in more rural areas if treatment's being rendered in a patient's home, but where access to reception is via Wi-Fi or something like in a long-term care facility or a skilled nursing facility, that's less of a concern. In terms of the relationships with facilities like those, though, stakeholders need to be conscious of their financial and referral relationships with those facilities because those dynamics can create significant sources of scrutiny. In terms of referral relationships, stakeholders should primarily be aware of federal and state kickback and self-referral rules, as well as state fee splitting prohibitions, and how all of the above primarily the federal anti-kickback statute and Stark law, can implicate the False Claims Act. The federal anti-kickback statute is a criminal law that prohibits paying or receiving remuneration in exchange for referrals or arranging for referrals if the items or services are reimbursable by a federal healthcare program. So wound care practices often interact with hospitals, skilled nursing facilities, long-term care facilities, suppliers, other providers, any arrangement where a practice receives or is providing something of value in exchange for patient referrals or the purchase of goods or services like skin substitutes. That may be, if that's going to be reimbursed by a federal program, then it presents an anti-kickback statute concern. Some examples of prohibited conduct include accepting discounted wound care supplies from a manufacturer in exchange for prescribing or using their products, paying facility staff for patient referrals, paying marketers for patient referrals based on relationships that they develop with those facilities, or offering free or below market services to facilities, providers, or even patients as an inducement for referrals or for continuing to use that wound care practice. Many states have their own kickback prohibitions in addition to the federal AKS. And those can apply to private pay. They can apply even when it's cash pay. And in a lot of cases, they're even broader than the anti-kickback statute for that reason. In a lot of models, folks try to refrain from rendering services to federal beneficiaries, and they think that that's going to get them away from any kickback scrutiny. But these state laws take a bit of steam out of that intention, because there can be similar liability at the state level. However, when we're talking about wound care, the likelihood that a provider doesn't accept insurance, especially federal reimbursement, is low. Most of these models are specifically rendering care to a Medicare and Medicaid population. And so we're dealing with not only the federal anti-kickback statute, but also these state laws on top. In terms of protecting against scrutiny, the anti-kickback statute has regulatory safe harbors that protect certain arrangements from prosecution if all the requirements are met. For example, a properly structured personal services agreement or management agreement, fair market value management fees, certain GPO arrangements, they can all be structured permissibly. Wound care practices just have to ensure that any financial relationship with a referral source or supplier is going to fit within that safe harbor to minimize risk. Oftentimes, the state level kickback prohibitions also incorporate federal safe harbors by reference, or they at the very least mimic them. So in a lot of jurisdictions, complying with federal rules can help a practice at a state level as well. Violations of the AKS can result in criminal penalties, including fines and imprisonment, civil monetary penalties, exclusion from healthcare programs, False Claims Act liability. The OIG actively is investigating and enforcing these AKS violations in the wound care space. In fact, each year the OIG lays out where it's going to be focusing its efforts, and skin substitute reimbursement is specifically on OIG's 2026 work plan. So scrutiny in this space is only going to increase. So far, we've seen a number of enforcement actions against not only wound care providers, but also wound care management companies. And these enforcement actions touch on not just the kickback issues, but also healthcare fraud generally and the False Claims Act. In just a bit, Guillermo is going to get a little bit more into some of the audits and investigations that we've personally been seeing as well, and where these can lead. In addition to kickback concerns, fee splitting rules are state specific and typically prohibit a licensee from sharing or dividing their professional fees with a non-licensee. Fee splitting is somewhat similar to a kickback, but it doesn't require that quid pro quo. So there doesn't have to be a referral in exchange for the payment. It's just payment being made to someone who wasn't involved in the professional services. This is another regulatory consideration that stakeholders, particularly the licensed stakeholders, need to be aware of, because these rules are commonly in the context of licensing board unprofessional conduct prohibitions. So states will vary widely on how they address fee splitting. New Jersey, for example, doesn't have a broad fee splitting prohibition separate from the potential corporate practice of medicine issues that may come along with sharing professional fees, but New York does. Both kickback and fee splitting prohibitions need to really be considered when we're talking about MSO models, because the management fee is likely to trigger these rules. When the manager is providing marketing and business development services, kickback rules can definitely be triggered. And even where the manager doesn't provide those marketing services, it still needs to be conscientious in terms of how it's calculating its management fee to avoid a situation where the practice is considered to have split its professional fees with the manager. Or even if the manager's acting as a silent owner of the practice, which gets us back into those corporate practice of medicine concerns. In terms of self-referral, the federal Stark law, also known as the Physician Self-Referral Law, prohibits physicians from referring Medicare or Medicaid patients for designated health services to an entity where the physician has a financial relationship unless an exception applies. Stark can be triggered when a wound care practice owns or is affiliated with a pharmacy or a DME supplier and is referring patients for wound care supplies or medications, or where the practice provides in-office dispensing of wound care products. There's a number of exceptions to Stark, but unlike the Anti-Kickback Statute, where meeting a safe harbor is optional to reduce risk, if a Stark exception is not met, the model will be deemed a violation of Stark. Generally speaking, Stark's a little bit less concerning in a wound care model where the practitioner is personally administering and providing a service like a graft, but it can get triggered in terms of follow-up care, like I mentioned, if there's orders that are being made for other ancillary services, again, in which case an exception needs to be met. Just a quick note on value-based opportunities, because there's already so much scrutiny of wound care reimbursement, these models can be prime candidates for seeking value-based care opportunities with payers, where the reimbursement's not based necessarily on fee for service and instead is based on outcomes and savings. I talk with a lot of my wound care clients about reducing hospitalization and the immense savings that can come with that. And this might be the angle to take when having those discussions with payers, particularly in the long term, as we're likely to see some significant change in reimbursement in this space in the future. So just to kind of recap, for wound care practices, understanding and complying with corporate practice medicine, anti-kickback statute, fee splitting, Stark, it's critical to building a sustainable, legally compliant business. Each doctrine addresses different aspects of practice structure and financial relationships. Even well-intentioned business practices like offering discounts or rebates or free services, especially to patients, can be problematic if they're tied to referrals of federal program business. So carefully structuring, documenting, and having ongoing legal review is really essential to avoid some costly enforcement actions and ensure there is a high standard of patient care. So with that, I will hand it over to Brandon.
Thanks, Arielle. All right, so to get started, I'm going to talk a little bit about scope of practice and supervision. And then I think Arielle's portion of the presentation actually dovetails great into the section I'm going to talk to a little bit about wound care transactions, both buying and selling, evaluating your practice, evaluating other potential practices for acquisitions, and conducting sell-side due diligence. So before we get into that, to talk a little bit about some compliance considerations with respect to scope of practice and supervision, Arielle spoke to this a little bit before, but the concept of scope of practice is essentially the scope of services that a specific provider type is legally permitted to provide in a specific state or jurisdiction. And that's a really important point to keep in mind while we're talking about scope of practice and supervision requirements. These are all state specific. So it's incredibly important for those of you who are interested in having a multi-state model or potentially, a mobile wound care provider operating in multiple states. Like Arielle said, the state where the patient is located is generally the state where the scope of practice rules are going to apply for a given provider, as well as the supervision rules. So with respect to scope of practice, it will, like I said, it will vary between your different provider types. Obviously, a physician, an MD or a DO is going to have the greatest scope of practice in every state. And then generally, as you move through mid-level providers, down to nurse practitioners, some states have independent practice nurse practitioners. Others require nurse practitioner supervision by physicians, then PAs, and then generally down to RNs, and then, med techs and other types of certified non-licensee providers. So it's really, really important to keep in mind that when a provider is providing a service, the service needs to be within their scope of practice, and you need to be satisfying the given jurisdiction supervision requirements. Supervision requirements dovetail right into scope of practice requirements, in that even though a particular provider in a particular jurisdiction may be able to, for example, provide a specific service or apply a specific product, they may need to meet certain supervision requirements. For example, if an NP in state A is providing a service X, that NP may need to be supervised by a doctor. That doctor may need to be within a certain geographic radius of that NP, and that doctor may be limited to only supervising a certain number of NPs or PAs or RNs, as the case may be. So as you can see, this is already getting a little bit complicated, and it can get even more complicated where you're dealing with multiple providers providing different services in different states, and making sure that you're satisfying both those geographic supervision requirements, the number of providers that can be supervised requirements, and just your general scope of practice requirements. One recommendation I have for all practices that are considering adding a new type of product or service line to their business is to consult with legal counsel to make sure that there aren't specific scope of practice requirements for that type of medical procedure or product, and to additionally make sure that there aren't specific state registration requirements with respect to that type of procedure or product. One example that I've seen in the wound care space with some of my clients recently has been the utilization of platelet-rich plasma, or PRP, treatments on patients. In many states, because PRP is considered to be a blood product, there are specific registration requirements. So, for example, in New York, there's a filing with the New York Department of Health you generally need to make. In New Jersey, there's a bit of a gray area on that, but there's new regulations that should be coming out in the next year or so. They're going to clarify when certain medical practices providing PRP services will need to register with the New Jersey Department of Health. So for new services, new service lines, when you're adding them to your business, don't just assume that there isn't some type of specific licensure or other requirement that you're going to have to meet. That is becoming more common with some of these more advanced treatments like PRP. One other thing I should mention is that scope of practice laws can also limit or impact the type of services that can be provided by via telehealth. So once again, if you're considering utilizing telehealth in your practice, it's also a good idea to speak to legal counsel to determine whether or not incorporating a telehealth model is going to require you to do anything differently than you're already doing, or have providers with different licensures in different states to handle, for example, telehealth encounters in other states where you may have a lower level provider providing the service in that state, but you may need to have a initial physical inspection discussion with a higher level provider before that service can be provided. So next thing I want to talk about is considerations when buying or selling a wound care practice. So the next part of my presentation is really going to be applicable to a couple of different circumstances, but a lot of the things I'm going to be talking about tie back to what Arielle was talking about, and are also just generally good compliance strategies for your wound care practice generally. So in terms of the things you should be keeping in mind, talk a little bit first about the sort of regulatory challenges here. Arielle went through these in detail, so I'm not going to go into the nitty-gritty on what these laws mean, but the first thing that you probably need to be considering, either when you're going to sell or when you're considering buying a wound care practice, is compliance. I'm going to talk about some specific compliance examples that I've seen in wound care transactions that I've done in the last couple of years in a few slides from this. But just to kind of touch on some of the things Arielle said again, investigating the practice's history of billing and False Claims Act compliance is super important here. I'm going to talk about this a little bit later, and I'm sure Guillermo will mention it as well, but utilizing professionals for this, Internal auditors, certified professional coders. It's super, super important when conducting a diligence on a wound care practice. Additionally, you really want to do a thorough billing audit and just really take a close look at how things have been done, because in a lot of cases, especially if you're considering inheriting existing payer contracts or relationships and you're considering a stock purchase transaction, you should keep in mind that when you purchase a stock of an entity, you're also purchasing all of its liabilities. And while we'll talk about indemnification and how we can apply that to sale or purchase transactions to try to protect us in a little bit, it's important to understand that indemnification is really only worth, the value of the parties. And a lot of times, if a practice isn't doing well or a seller leaves a business and there's an audit and you come after them to try to sue them because they didn't disclose some kind of massive billing or coding issue, many times you're not going to have recourse against them because they're just not going to have the funds to cover, for example, a multi-million-dollar audit now that you've, purchased their business and they've kind of, sailed off into the sunset. I'll also talk about anti-kickback statute, Stark law violations more specifically a couple slides from now, but it's really, really important to analyze all of the different referral relationships that exist within the practice, especially vendor relationships, marketing relationships. We'll talk about those a little bit later. It's super, super important to do that. This generally involves evaluating contracts. Part of your diligence process, which we'll talk about in the next slide, is going to involve going through all of the contracts that exist and figuring out whether any of these types of relationships are problematic from either a compensation, referral, or other standpoint. Also, we talked a little bit about state-specific regulatory compliance. Arielle spoke to it a bit, and I spoke to it a bit in the scope of practice section that I just discussed. But once again, licensing requirements, corporate practice of medicine laws, these need to be an integral part of your diligence process. Whether you're buying a practice or you're considering selling your practice, you should be figuring out whether or not your structure is properly set up for all of the jurisdictions you're operating in, which often requires you to have multiple entities, as Arielle mentioned before. Next, I want to talk a little bit about conducting due diligence and something we refer to, as transactional attorneys as sell-side due diligence. A lot of times when people think of diligence, they think about, a buyer coming in and evaluating an existing practice, MSO, supplier, you name it, and try to find, liabilities and risks before they enter into a purchase transaction. Sell-side due diligence is sort of the opposite of that. It's actually when you're considering going to market, basically analyzing these things before a buyer does, potentially restructuring or potentially cleaning up any issues, whether they're compliance issues, structural issues, et cetera. That way you can kind of get the best deal possible. In terms of sell-side due diligence, it's unlike buy-side diligence. It's really designed to find flaws in a business, which is designed to find flaws in business, Sell-side diligence is really designed to ensure those flaws are resolved or mitigated. Some of the benefits to this are it really maximizes the value you're going to get. Often when folks are talking about transactions in the healthcare space, they, talk about EBITDA multiples or, how much of a multiple can you get based on, the practice you're selling, the current market. And one thing that sell-side diligence can really allow you to do is to, maximize the multiple you're getting and minimize any potential indemnification requirements. I mentioned indemnity before, but I think now is probably a good idea. Now it's a good idea to tell you a little bit about what that means in the context of a transaction. So the concept of indemnifying a party means that you're going to essentially hold them harmless and reimburse them in the event that you violate, certain representations, warranties, or covenants in the purchase agreement. So, for example, the purchase agreement may contain certain representations or warranties regarding the structure of the business being compliant, or the fact that the business has not violated any healthcare laws. By performing sell-side due diligence and going into your business, making sure that you restructure it to be appropriate for every state it's operating in, making sure that you cure any impermissible referral relationships or make any required self-disclosures. Doing all of this before you go to market and start talking to buyers avoids you having to potentially indemnify them for these risks, or at least minimize the indemnity obligations that you have. And also, when buyers identify these types of risks, they generally devalue the business because they're taking on more risk by purchasing you. So by going in, looking at your structure and addressing these things in advance, you're going to maximize the value of your practice. You're going to improve your negotiating leverage. You're going to reduce demands on the practice's internal resources during a sale transaction, because I can tell you, trying to run a medical practice while also trying to close a sale can be extremely difficult and harrowing. So avoiding that is incredibly important. And it also just helps to facilitate a more expeditious closing. I mean, ultimately, everybody's paying money to get a transaction done. So getting things done quicker, more efficiently, and with less risk to the parties saves everybody money, makes everybody more money, and is just generally better all around. Some other topics within the sell side diligence, some things you want to look at. Generally, the first thing we'll look at, like I said, is organizational documents and structuring. As Arielle mentioned, when you're utilizing an MSO model, this is extremely important. Some other things we look at are the voting requirements. What are the partners' voting abilities, and what rights do they have at different career stages? And we consider amending them, especially to clean up open-ended purchase rights and things like that. We also take a look at the assets, their condition, title to the assets. Do you hold them? Are there liens or security interests you may need to worry about? And then we look a lot at the different contracts you have. And I'll talk a little bit about this when I talk about vendor relationships in a couple slides from now. But once again, it's really, really important to make sure that the contracts you do have, especially to the extent that they generate referrals, fall within a safe harbor. As Arielle mentioned, most management contracts, especially in the wound care space where we're dealing with a lot of federal reimbursement, should be structured to meet the personal services management contracts and outcomes-based arrangements safe harbor. That generally requires, a fair market value, commercially reasonable management fee. It's generally going to require that the contract be entered into in advance and, set forth in, writing all of the specific terms. That may involve getting a valuation to determine whether your management fee is legitimate. And, these are all things that you should consider if you're thinking about selling your practice. In terms of some other things, licenses, permits, like I said before, really important to make sure that you have all your ducks in a row with respect to all of your service lines. So if you are providing PRP, for example, do you have the correct registrations and licenses for each state where you're providing that services, that sort of thing. So just a couple of other things, just kind of high-level recommendations, whether you're buying or you're considering selling. You should speak with in the instance that you're buying, you should speak with the seller's legal counsel, and you should review their compliance policies, especially with respect to False Claims Act, Anti-Kickback Statute, and HIPAA compliance. These are huge potential risk areas in wound care, and there are certainly a lot of non-compliant contracts out there. If you are looking to sell your practice or to acquire practice with the least amount of risk possible, it's imperative that you do diligence, you see what they've done already, and then you take a look at it to make sure that you agree with it. This is especially important in multi-jurisdiction practices when you're either bolting on a practice in a new jurisdiction or you're acquiring a practice that operates in multiple jurisdictions. Financials and reimbursement, once again, as we discussed earlier, in terms of billing and coding, having someone do an audit and hiring a certified professional coder to do that is extremely important. And like I said earlier, negotiating indemnity clauses is going to be super important here. Like I said, if you are selling your practice, doing sell-side due diligence can really reduce your burden from an indemnification standpoint, because there's going to be a lot less risk, and you'll be able to demonstrate that because you can show the buyer's legal counsel that you've properly structured it and you've made proper considerations. So I want to talk a little bit about the types of professionals you need when preparing for a sale. First and foremost, in terms of legal counsel, wound care is so complex with respect to its interactions, especially with federal fraud and abuse laws, that it's imperative you have a healthcare attorney review it. Whether it's us or another healthcare firm, you should have attorneys that specifically understand the state and federal fee splitting, and healthcare fraud and abuse ramifications of certain transaction structures. And you, especially if you're going to sell your practice, you should consider talking to a healthcare attorney before you do, to make sure that you are properly structured for that type of transaction. Or in the instance where you're going to, for example, set up for a private equity sale, you may want to consider adding an MSO model to your business, because private equity generally will utilize an MSO model, and wrapping all of those assets up for them and having everything ready to go will once again reduce risk and cost for them and lead to you getting a higher purchase price or EBITDA multiple. Next up, accountants and valuation experts are extremely important. Valuation experts are probably most important when looking at a management services organization or MSO model. As Arielle mentioned earlier, in order for an MSO to pass muster under the personal services management contract safe harbor, the management fee that it's charging to the professional entity needs to be fair market value and commercially reasonable. Generally, best practices is to back into that determination by using a nationally accredited third-party valuation company. We work with them all the time, and it's integral whether you're creating an MSO, buying or selling a practice. That analysis is key. Next, brokers and investment bankers are incredibly important. You want to make sure that you're getting yourself in front of the right buyers. Having the right broker and investment bank that are backing you up are going to allow you to present your deal to 10x the amount of buyers as if you tried to go out there alone. And that is going to give you more options in terms of who you want to partner with. And more obviously, it's going to potentially get you a higher purchase price because you're going to have 10 people bidding for you instead of 1 or 2. Finally, as I've mentioned earlier in my presentation, billing and coding experts are incredibly important. Whether you're conducting an internal audit before preparing for a sale, or considering purchasing a new wound care practice or MSO, you should be hiring a certified professional coder. You should be auditing how they do all of their billing, and looking at their vendor relationships once again to make sure that they're compliant. Care transactions. First, something called earnouts. So an earnout's a provision in a purchase agreement where a portion of the purchase price is contingent upon the seller or the acquired business in most cases. So whether it's a new company or the old company with new ownership achieving certain performance targets after the closing of the transaction. So this is most commonly expressed as there'll be an increase in revenues of 10% in the first year, and maybe that will entitle you to an additional $1 million. Or if you fail to meet that, maybe there is going to be a reduction in the purchase price or deferred payment or something like this. So it's important to identify these whenever you're entering into a purchase or sale transaction, because they do generally implicate federal fraud and abuse laws, specifically the federal Anti-Kickback Statute, if they're not structured correctly. So one example, if an earnout's tied to referrals or the volume or value of services provided to federal beneficiaries, it could be problematic. One thing I've seen in problematic transactions in the past is that, for example, a wound care practice is going to be integrated into a larger wound care practice, and part of the purchase price is going to be based upon how many new skilled nursing facility relationships that new practice generates in the year after the sale. So once again, you can see how that amount of money is now being tied directly back to the generation of referrals. Finally, one last thing, in terms of vendor relationships, as I mentioned earlier, it's extremely important you scrutinize these as well. Anti-kickback statute concerns run abound in the vendor space, especially in marketing and wound care. You should be especially cautious of any types of arrangements where a marketer is going to take a cut or a percentage of a specific, for example, if a referral is worth $800,000 and they're taking $200,000 or 25%, that is generally falls right into the bucket of a payment in exchange for a referral. And sometimes these can be masked by using multiple transactions and other things. So it's just important when either you're buying or selling a practice, or you're just looking at a new vendor relationship, very important to scrutinize these types of relationships. All right. With that, I believe I can give it over to Guillermo here.
All right. Thank you so much, Brandon. And I'll be somewhat brief about this since I know we don't have too much time left. But the most important thing here is I want anyone who's listening to this, either live or in a recording, to understand the basics of what a wound care audit is and why you want to listen to the advice that Arielle and Brandon gave earlier, both of them mentioning use of certified professional coders, self-auditing yourself, making sure that you're in a strong position, because you want to talk to Arielle, you want to talk to Brandon. I hate to say, most of the time people don't want to talk to me, because when they talk to me, it's because someone's investigating them or something went wrong, or you didn't listen to them, and now you have to listen to me talk. So wound care audits are a hot button issue. We have been writing about this for the last 18 months. We handle a high volume of audits, and we saw this on the horizon. And for once, I'm not going to be beating up on Horizon. I'm actually going to be talking about the CMS, because they are brutal when it comes to auditing practices. If you think about wound care products, you're talking about skin grafts that are the size of a postage stamp, and they cost about $10,000 plus in reimbursement for something that small. Could be more depending on the product. So it is a very easy thing for the CMS to pick on when they're trying to look through, well, how are we going to recover $880 billion in fraud that the government wants to recover? They're going to go after the big ticket items, and this is one of the biggest ones. The look back period for a UPIC auditor, that's a Uniform Program Integrity Contractor. They investigate fraud, waste, and abuse for the CMS, is 6 years. So 6 years worth of wound care services is an astronomical figure. Most of the audits that we deal with are actually not extrapolated for wound care, but they regularly come in between 1 and 5 million in the overpayment demands. So it's crucially important to understand that when you're talking about wound care, you're going to be talking about a high ticket item, and it's getting harder and harder to go under the radar, because even with moderate use, you're still going to be billing Medicare very high volume. Because practices bill for the product that they purchased, the biggest part of the bill isn't your services, it's actually the product, the pass-through cost. And when the CMS comes after payment, they don't care that 90% of that went to a lab company. What they care is your, NPI was attached to the tax ID number used on the specific claim, and now they want you to pay them back. They don't care whether there's any indemnity agreement with the lab company. They don't care whether you footed the bill and now, you spent that money and you don't have anything. We've seen practices go bankrupt. So the CMS can be ruthless about this. And when you get the overpayment demand, that's going to be high 6, low 7 figures. It's going to come with a generous interest rate of about 12.7%, which is illegal anywhere else in the United States, but not with an overpayment demand for some reason. So to understand, a wound care audit, like any other audit, are you an outlier compared to your peers? Do you do a lot of wound care compared to other wound care specialists? Provide a taxonomy. That's getting a lot of providers. If your NPI is for a family practice, and now all of a sudden you're doing a significant amount of wound care, you're going to get audited automatically almost, because other family practitioners are not doing wound care, and that goes across the board. And then lastly, enforcement area. That is right now what wound care is. A couple of years ago, it was amniotic products, it was stem cell products. Now it's this. So when you have to understand, generally speaking, the CMS, if you did not listen to Brandon and you purchase a practice and it didn't violate, with its contracts violated the Anti-Kickback Statute or the False Claims Act, the CMS can look back 10 years to take money back. And if it's egregious enough, they can refer to civil or even criminal prosecution, which we've seen. So audit yourself on everything that relates to wound care. Make sure your clinical justification is there. Make sure you're coding accurately. Make sure that you're using the right modifiers. If there's wastage, that you're noting it, because these are low-hanging fruit issues that you can correct. In the next slide, I'll talk to you now about common provider pitfalls. And these are things that get my clients in trouble more often than not. The number one is at the top: late or incomplete responses. We have clients that routinely come to us and they said, well, we had our biller help us out, or, we just had, someone, at the medical records department figure it out, or the front desk person did it. Their license isn't on the line. Their paycheck isn't on the line. Yours is. So you have to make sure that you double and triple check everything that goes out. If you send out records and you only send out, for instance, the date of services that are being audited, but you don't include the conservative care that led to that, that's 100% denial. We're helping practices with large 7-figure overpayments and we ask them, can you just send us a copy of what you sent to the CMS? Maybe we have to do a supplementation. Maybe we have to do something a little different, maybe an attestation. And we see that what they're sending is bare bones. Or worst case scenario, we have, again, not to harp on billing companies, because some of them do a great job and they're very good at this. But sometimes, if you have an overworked biller and the practice says, can you please just handle this appeal for me? And they don't do it in a timely fashion, there's no excuse for that. The CMS has zero leeway and their deadlines are written in stone. So if you miss an appeal deadline by an hour, then you're out of luck. We had a situation once where we filed an appeal in a timely fashion. It got there on the date it was due, and the CMS marked it late because they go check their PO box at 8:30 in the morning, and our package got there at 9:15. And then the next time they checked it was the following day. They marked it received the following day. They said it was late. So we had to file a whole thing to get it overturned. We eventually did, but that's the type of mentality you're dealing with. That's the type of red tape that you have to deal with. So it is a full-time job. You literally have to pay me to do it. So don't just think that someone's going to be able to do it as like a side hustle. It takes a lot of care, detail. You have to be meticulous about it. You have to be very type A about it. Get help, get legal counsel involved, get certified professional coders to look at your records. You want to make sure that you're submitting everything and you're doing it in a timely fashion. Avoiding your records, anything that's boilerplate, anything that relies too much on EMR, auto-population, because what auditors like to do all the time is look up at, they hold up 2 pieces of paper, 2 dates of services. If they look, identical, if they look almost exactly the same, they're going to say they're cloned notes. And then they're going to throw out everything. Baby with the bathwater, every code you build, every service involved, it all goes out the window. Always have all your key pieces of documentation. Wound measurements, that's like the gold standard. If you have images, photos, before and afters, if you did any debridements, you have to have the measurements before and after the debridement. You have to show the patient was a good candidate, failed conservative treatment, and how are they progressing with the wound care. That's the overview of what you have to do. If you go to the next slide, Arielle. Your appeal rights and process. I'll go over this one real quick. So with the CMS, there's 5 levels of appeal. We really focus on 3 levels. The reconsideration is the first level. The redetermination with the QIC, which is an independent contractor, but as I like to tell my clients, they're about as independent as they can be when someone's paying them to be independent. So a lot of times they will side with the CMS. And then the third level is when you finally get your day in court, which is an administrative law judge hearing. An administrative law judge hearing, I would say 98% of the time, the CMS, the QIC, The UPIC auditors, they don't even show up. On a rare occasion, maybe 10% of the time at most, probably 5%, they'll send a position paper that's just regurgitating their prior denials. They don't have the audacity to show up. We can really get the best results at this level. But to get to this level and be successful, you have to put in the work at the prior levels of appeal. You have to create a record. You have to produce expert reports. The second level is important because at that QIC level, when you file that appeal, you close the record. You can't add anything after that. We've had some heartbreaking discussions with some providers who retained us to do the ALJ hearing. And then at the hearing, we realized there was an invoice missing, which was the smoking gun, which would have allowed them to win. And it was never produced at the lower levels. It was even asked, to be produced by one of the auditors. And in the response, it wasn't produced. If you didn't produce it, even if it exists, they're not going to give you credit. So it's crucial. Get attorneys involved early, get healthcare counsel involved early, because we've had situations very recently where we've had clients come to us at the ALJ phase, and we have to tell them your prior attorney didn't do something that they were supposed to do. You're now out of rights. You have no further appeal rights, and the ALJ dismissed your case appropriately. Healthcare is a niche. You don't dabble in healthcare. This is why I do what I do within healthcare, because it's that complex. And then I refer out issues, related to compliance and regulatory matters, to Brandon, to Arielle, to some of my other partners. You really need to know and understand in this space. I've handled probably over 1,000 audits over the last 5 years. I still learn. Okay, I'm still learning. So for someone to say, yeah, I can handle that for you, they can handle it, but do they know what they're doing? And that's why you really, even if you don't go with Frier Levitt, you have to go with healthcare counsel who has a dearth of knowledge in this space. You have to understand, for instance, that each level has different strict deadlines. If you want to stay recoupments, so that $5 million overpayment demand doesn't start getting recouped from current claims, you have to file your appeal within 30 days. You have 120 days to file a first level reconsideration, but you have to file it within 30 days to stay recoupments. At the second level, you have to file within 60 days to stay recoupments. 180 days is your total deadline. So you have to understand that there's nuances to this. If you can go to the next slide, Arielle. This is the one that everyone should remember. This is why you challenge audit findings. A lot of times audits are woefully deficient and wrong. Auditors get it wrong all the time. You have made up policies. A lot of times we'll go up against a regional contractor, a MAC, that will say, well, this doesn't apply to, local coverage determination L3457. And we look it up and it's from a completely different MAC in a completely different region. They're just borrowing, they don't have their own LCD. Or they'll say, okay, your documentation is fine, we agree, but your product is experimental. We don't believe that, that this was subject to a peer-reviewed double-blind study. And then we ask them, well, where does it state that it has to be peer-reviewed double-blind study for this product that got a Q code from the CMS that the FDA doesn't deem it to be experimental? Why is it that all of a sudden now you as the QIC or the MAC are saying that it's experimental? We run circles around them with these kind of arguments. There's a lot of studies out there. Some are very product specific, some are more generic, but there's ways you can beat every type of argument with the CMS. The ones that are the hardest to overcome, of course, are documentation deficiencies. In cases where you just didn't take measurements of the wounds, you didn't use a modifier to show there was wastage, simple stuff. But that simple stuff is 100% preventable and it is 100% curable. You need a certified professional coder to independently audit you and to get you, on the right ship here. You don't want to be low-hanging fruit, and you can't get multiple unsuccessful audits because at a certain point, the CMS says you clearly don't know what you're doing, and we've seen them try to terminate CMS credentials and kick practices out of the CMS or suspend their billing privileges due to repeated multiple failed audits. Lastly, the last slide, I'll run real fast through it, just so that you understand case studies that we've had here. Please never delegate productions to people who have no vested interest. This could be, the case of the biller who just sent in bare bone records, or someone within your own staff who was handling a prepayment audit and decided to, resubmit a failed audit by just changing some stuff on the record so it would pass the audit. Problem is, when you change something on the record just to pass an audit, it's not an addendum anymore, it's an alteration, which is fraud, which can bring about, prosecutorial attention that you don't want. Don't trust the auditor's findings. We have overturned multiple 100% error rates into 0%, fully unfavorable to fully favorable decisions with the CMS. I could tell you anecdotally, I could tell you just from experience, in aggregate, there's always something you can challenge them on. And the CMS is losing a lot at the ALJ phases when you push them that far. Keep pushing, keep appealing, keep going to that ALJ phase. Have experts, have legal counsel at the ready. It's very important that you keep attacking them. When their documentation attacks fail, they get desperate, they change mid-audit their rationale for the denials, and they'll call it experimental. There's ways to do that. We work with lab companies that actually produce these products. We've spoken with their medical directors. We have a significant amount of studies that we use when we file these appeals. Don't just accept that. It's not experimental. And lastly, if there's not a policy or local coverage determination on point, they like to borrow one or make it up. If there isn't an LCD on point, it defaults to the lowest bar possible, which is medical necessity. Was it medically reasonable and necessary for you to provide this product? Did conservative treatment fail? Is this a good product that's efficacious and safe? Is this a product that is the subject of studies, or a product type that has been studied before and approved? Do you have the measurements of the wounds? Did you bill the correct amount of units? Did you use the smallest size possible? You go through the laundry list of things that are common sense that I'm sure all of you are already doing. You put it in a very easy to digest manner for the auditors. You appeal it. You get denied at the first stage. You appeal it again. You probably get denied at the second stage, and then you get to the ALJ phase, and that's when you get your figurative day in court because it's a phone call with an ALJ. So in closing, we want to thank you for taking your time out of your busy schedule to join us today. We hope that you found the discussion insightful and informative. As mentioned earlier, there's going to be a link to today's recording that will be included in the follow-up email for you to view at your convenience. And if you have any questions or need further assistance, please don't hesitate to reach out to any one of us. We're here to support you as you navigate these complex issues. Thanks again for your participation. We hope you have a great day. Thank you.